I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into our 40-second compilation. Before I give you the rundown on the judges, I just want to let you know there will be no commentary at the end of this one. And also, there will be chapters added. As you guys know, these are some classic moments that we've had here previously on the channel. And with that being said, guys, let me go ahead and give you the rundown on today's judges. First, we will be in the courtroom of Judge Tammy Long Hayward out of the state of Georgia. Second, we will be in the courtroom of Judge Jason Elmore out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Sean Perkins, also out of the state of Michigan. And as always, I appreciate you guys joining me. Don't forget to like, share, and subscribe. And I look forward to catching you guys on the next video. And with that being said, guys, let's go ahead and jump into this compilation.
All right, DeMarcus Cantrell Brown.
We are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
aka Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
I not right now. I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, till January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right? Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay.
Okay. I got you. So,
all right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have...
Wait. You see this book right here? This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not
books. Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So you say it's not a difference between public and private for the record. There's no difference.
Sir, get an attorney.
Okay, all right. January 5th.
Yes, sir.
Okay.
And Mr. Bay / Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them. So first of all, right here. The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney. Okay. Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m. So DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
Is the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to state and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on. Let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay. Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off mute.
What's going on is he's a member of a foreign state corporation, basically doing business in Georgia. So
okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying, man.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you on.
We understand the rules of the court. We understand the rules of the court. I got you.
Okay. Are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
what I'm trying to realize
then as he can represent himself,
you need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia, but he cannot have you represent him or purport to represent him. Okay, that's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
that would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot practice law from the bench. Violation on USC 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
I object.
All right, sir. Thank you. You'll get notice in the mail. If anything changes about your address, then you can go ahead and let us know by coming in.
I demand an evidence hearing.
You will have that at the time of the trial,
an evidence hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
you are dishonorable. I got your oath, Tammy Long Hayward.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present. Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time. All right, Kevin Jermaine Burrows.
And now we're down to people of the state of Michigan versus David Thompson, file 24-3559FH.
David and Houghton, appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here. We can go to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right, well, all right, so we are currently set. Sure, you can have a seat. Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pretrial conference. Today is the last date in which to enter a plea pursuant to any pretrial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have two trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials in that 2-day time frame.
And was there a jury demand, I assume?
There was, yeah.
Right. I'm going to move this to start on February 19th. So that way we have the 1 day to do the other file and the second day to do this case. So I'll issue jury letters to 4 sets. 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct. Sir.
You understand the court can appoint an attorney to assist you?
Yes,
yep.
is.
I know. Yeah, I know he's helping you,
yes.
But you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right, and you understand that while it might seem illogical. I have to, by law, require you to follow the same rules in the courtroom, okay? So if you need to enter a piece of evidence into, I'm sorry, an exhibit into evidence, you're asking questions, you're gonna have to follow the same rules, okay? And just make sure you say yes.
Yes.
Thank you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law. Equity should prevail. I'm prepared to wrap this up and settle all of this. I've done here in this venue. That's exclusive of Article 3. Constitutionally speaking.
Yeah. I appreciate, I appreciate that interest, but I can't. And let me explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here. I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's 2 charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the 2 parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these 2 gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here, we can't do that. The law does not allow me to resolve this case unless you were all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay.
Could you please repeat yourself the last 2 sentences, because I heard something in there. I want to make sure I heard it correct.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me. There's no jury and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least, Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's
okay. It's all right. That's what I'm here for.
And I do appreciate you bring up the Constitution, because the arrest regarding when I was arrested in this matter was done ex parte. I had no notice of this.
It's okay.
Their client.
An arrest warrant can be issued ex parte. The law allows that. There are rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've done read that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says it just says an arrest without a warrant is illegal. But the Michigan law doesn't, Michigan law tells us what we can do, or what, sorry, not we, but law enforcement can do, because they don't work for me. I don't work for them. they have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not here to argue, I'm just
that's okay.
making you aware of what's happened.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th, sir. Thank you. We're on the record today, 28 on the circuit court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhouten on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things. The law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor. Yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. Even though it looks like the information was dated February 5th, but filed on the 6th. Now we're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first. Because a resolution means an agreement. Mr. Denhouten, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that block. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with the ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236 under section 600.576. Depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. And I'm still trying to make sure all of this gets settled and closure in honor.
Oh, okay.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or I
You
do my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay, let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced
576, Your Honor.
Okay, and how do you think deposit? What did specifically again? Did you deposit
A certificate of security.
Okay, and so what security was it that you tendered?
That was consideration
Or
any outstanding liabilities, Your Honor.
okay, so your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right, so and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right, so are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, you don't owe anything.
My knowledge, I do not. I have
No, so
my knowledge, I'm free and clear of liability, Your Honor.
No, liability is a different word. Liability doesn't apply here yet, right? There's no judgment that says you owe anybody money, so there's no liability.
Thank you for correcting me.
Yeah. Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
no, multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the green card resent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium. So we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota. That's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're going to get 2 bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhound reach an agreement, that's between you guys. I don't care what you guys deal with right outside. There's nothing to do with me. Mr. Denhound says they don't have an agreement, which means your offer has been, at least at this point in time, rejected. So now the next question here is, so that means we don't have a resolution today. I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, because so far it doesn't end the case. you can't pay off a fine until I order a fine. So therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition. The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any
I'm not
body?
sure.
Yeah,
Sorry
it's
to
okay.
interrupt
It's
you.
okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, it should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, I believe it has been submitted, but I don't believe we have a copy of it yet.
All right, so that means I turn over here, and I'm just going to say on my discovery issue, still,
Your Honor, I stand corrected. I do have a copy of it.
never mind, I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those, you say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. You'll get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab. So things like that. So you can ask questions about discovery. But so far right now, it seems like you have it. But again, if you look at that police report, look at the last 2 pages, it will list all the exhibits, and you're going to want to make sure you've got those exhibits. And typically there's some kind of body camera. Now, by the way, unlike what they show on television, not every body camera works all the time. Not every body camera gets digitally downloaded for some reason. I don't know why, but you just can find out that information. And sometimes, by the way, they're muffled. Good luck figuring that out. All right. So we don't have a resolution. We don't have any discovery issues. The next question is do we have any motions? Now, Mr. Thompson, inside my schedule order, I said, if you have any motions, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay. Now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond, and there isn't a right to a trial. There is no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then if so, what should I do? Should I revoke bond? Should I remand the defendant into custody? Should I modify the bond, or should I just wag my finger if they don't do that again? Now, do we want to have a hearing on that? Do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Misaki Community Corrections Program. Miss Stark, are you here for this one?
Yes.
I just want to ask you this question. Have there been any other alleged violations?
Two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right. Any I assume they've all been negative?
Just positive for THC.
All right, and that probably wasn't listed. Okay. All right. And by the way, Mr. Thompson, if you admit to failing to show up for those two tests, I'm just going to go with the finger wag. If they don't do that again, make sure you show up. Okay. Is it true you failed to appear for those two tests?
By mistake, I did, Your Honor.
Okay.
I apologize on behalf of the court.
As long as you've been going to testing and you've been, and it just was on a couple different events. I will note they appear to both be on a Sunday. So I'm just going to say, make sure you don't. The court finds that there's been a bond violation, but the court is not going to revoke, modify the bond. I'm just going to do the finger wag. There we go. All right. Yes, sir. Anything else?
I wish to express gratitude, and I appreciate the court in its leniency. And I also want to let the court know that every day of my life is getting better.
I'm glad to hear that, Mr. Thompson.
I appreciate the opportunity to improve.
All right, so I don't think that Mr. Where's Mr. Trell Grigsby's file? Say Kinsman. Do you want an attorney, Mr. Grigsby?
No, sir.
I didn't think so.
I'm not, excuse me, I'm not, again, I'm in special appearance of Contrell Grigsby, and no.
Well, I need Contrell Grigsby. So whoever, if you're not Contrell Grigsby, then we're gonna put a warrant out. We're gonna put a warrant out for your arrest.
Well, I'm in special appearance of Contrell Grigsby, and whatever.
Right, so I have Contrell Grigsby.
Like I said, I'm in special appearance of Contrell Grigsby, and I do not need an attorney. And he do not, whatever you want to, he do not need an attorney.
City of Detroit versus Contrell Grigsby, case number SP 168-33921, SP 168-339-3, counts 1 and counts 2. Appearance for the record, please.
And special appearance of Contrell Grigsby Jr., Shuri Juris and Proprio Persona.
That went over my head.
No rights. I do not waive no right, none of my rights.
All right, Woody is today is the date and time set for a pretrial. What do you want to do with these cases?
Should be taking it. First, I want to I have added 2 pieces of documents to the court. I want to put them on a record. And my affidavit of conditional acceptance and my Naturalization Act of 1779 I already had on the record. So
I want to take it. You don't see this phone? All right. What do you, okay, that's on record. What do you want to do with these cases?
I'm fighting.
All right, so you want a trial date?
Yes, sir.
I'm going to give you a jury trial date. let a jury of his peers determine whether his innocence or guilt. Jury trial date, please. In person. The trial date will be in person.
Jury trial. Can handle this. Can this right be handled in private? I request that my this be handled in private. I don't
know what you're talking about. All court appearances are public.
Yeah, all right.
Let's pass it. We're gonna get a jury trial date and we'll go from there. And all the parties must appear. You don't have to be in person on that, but I want the officer to appear as well, because we want to make sure there's a lot of noise in the background. Somebody's got a lot of noise. That's going to be it. I think that might be your background, Mr. Mason. But I want to make sure that that we don't order a jury and it's not going to be actual trial. So June 9th, final pre-trial. June 10th, jury trial. That will be in person. And for all the parties.
Is there since you said you you don't have my documents, is there like a way that I could personally send them to you? Like, can I get like an email or something?
You can bring them down to the court.
Okay, cool.
You need to file them the proper way.
Yeah, I came down. I went down to the Coleman Young building. And then they said this is not a felony case. They sent me to 36th district, and 36th district said do it, online. Well, I did it online in like April.
So if it's online, maybe it's in the system somewhere. You can always drop a copy off with always drop a copy off.
If I may, Your Honor, if I may interject, Your Honor, I'll give Mr. Grisby my email, and we can communicate through email. Mr. Grisby, I'll put this in the chat for you, okay?
Yes, thank you. I appreciate you.
You're welcome.
And the court's gonna need a copy as well, an original copy, so that'll be, Mr. Grisby, you have the dates, right?
Okay, I got a date, but no time.
8:30 for the pre-trial.
8:30.
And it's gonna be 9 a.m. for the jury trial.
9 a.m.
June 10th. June 10th, so come to
June 9th.
June 9th at 8:30 and June 10th at 9 a.m.
All right, and you said I could drop it off down at 36th District Court. So who do I bring it to when I come down there?
You can bring it to the courtroom and bring it to the clerk.
All right, court 434.
All right. If there's nothing further, any
And
further
Mr.
questions?
Hold on, Your Honor, if I may, Mr. Grisby, I just put my email in chat for you, so you can email your documents for the prosecutor's office. You can email the prosecutor's office at Dia Mason. Okay?
Yes, thank you. I appreciate it.
And we will send our documents to you when you email us, so we can email you as well.
Okay. DIA Mason at Detroit.
All right, if there's nothing further, sir, have a very good day. Best of luck to you.
You're all set.
You as well. Peace and love. Thank you. I appreciate y'all.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.